Good morning. My name is Veronica Chapman. I'm a 2L here at Colorado Law and the current president of the Silicon Flatiron Student Group. I'm pleased to announce the AI and Write-Up Publicity and Federalism panel. Our moderator for this discussion will be Blake Reid, the Associate Professor of Law here at Colorado Law, with presenter Zahra Takhshid, Assistant Professor of Law at the University of Denver Sturm College of Law, with panelist Anne-Marie Brighty, Senior Copyright Counsel at Google, and panelist Mike Conover, founder and CEO of Brightwave, and lastly, our panelist, Margot Kaminski, professor at Colorado Law School. Thank you.
All right. Well, good morning, everyone. Nice to have everyone back for day number 2. My name is Blake Reid. You may know me as the loser of last night's debate, ignominious performance. But let's talk about winners for a second. Got to shout out the CU Buffs women's basketball team. Big win over Texas Tech yesterday. 11-1 at home. Go Buffs. Shout out to our colleague J.R. Payne across the pond. Okay, basic idea for this panel. We're going to bring it down a little bit from Mike's talk. We're going to talk about some problems with AI. The basic idea here, as generative AI and other advanced means of content synthesis proliferate, what harms flow from people's name, image, and likeness being appropriated, and what, if anything, should we do about it? We've got an all-star crew of folks to chat about it. Unfortunately, for folks who are watching online, I don't know. You don't know if the people that you're going to hear from are really who Veronica just introduced. It may be AI deepfakes. It may not even be me here. You'll just never know. But here in the room, you can come meet us all afterwards and find out if we're for real or not. We are going to start with a presentation from Zahra Takhshid, and then we will get into it from there. So Zahra is going to present on data as likeness. Zahra, I'll turn it over to you.
So good morning, everyone. It's great to be here. Thank you so much for making time in your busy mornings to come and listen to some writer publicity and tort presentation. As Blake kindly introduced me, I am a tort scholar and who is also interested in technology, and I try to blend the two. Sometimes it's successful, sometimes it's not so much, but I think these days tort has become an empowering tool for us in terms of trying to figure out what kind of liability regime is best fit for some of these AI challenges and data privacy challenges that we're having at our current moment. So to give a brief preview, maybe in terms of where is this common law privacy tort coming from, I know you're all legal scholars, but sometimes privacy torts are not covered in the 1L tort classes because of how much material there is for torts. So that's why I personally teach this in an advanced tort class that covers privacy and defamation. So you may all know that in the U.S., one of the first decisions that really brought into question in terms of protection of face and image was Robertson versus Rochester. So this case came about after the most influential law review article one can claim was published, which is called The Right to Publicity, which was published in the Harvard Law Review. And in that article, the authors argued for a right to be let alone. So at the time, there was no common law right to privacy. So these authors write this, and then we start having cases that try to invoke this common law notion of right to privacy. And one of the first one that is often cited, although there is question in terms of African-American history in terms of privacy, and Professor Anita Allen has challenged this notion of, was it really this lawsuit that was really the first one, or was it just because it happened to attract attention at the time that invoked the right to privacy? So with that background in mind, Robertson versus Rochester is really a case about a lady who was upset about having her image published on a pack of flour, as you see in this image. And she complained that this was without my consent. I had no idea I was harmed. She cites to her injuries being devastated, being humiliated, and tries to also show that it wasn't only just being upset, but also physically and emotionally being upset from the consequences of having her image published without her consent. And the court really dismisses this lawsuits and says, you might also say, and they're writing on this, some sexist tone, that you should even be proud. People take this as a compliment. How are you even upset that your image has appeared on this box of flour? And denies her right to privacy, a common law privacy. So also at the time, the New Yorkers were so outraged by this decision that how could you allow this to move forward, that they actually passed a law and enacted a right of publicity or appropriation tort as in their legislative body. So, but again, in terms of common law, she was denied until later. This is the law that was passed in New York that says any person whose name or image was used without their consent for the purposes of trade could sue for damages for the injuries sustained. So this case was really the first case that recognized the common law right to privacy. Pavicic versus New England, which was a court in Georgia. Mr. Pavicic had also argued that his image was published without his consent in an insurance advertising ad. And he said, again, how dare you publish my image without my consent? And in that particular case, the Georgia Supreme Court decided that, yes, you're right, this is outrageous, and there is a common law right to privacy. And the author of the decision goes deep into even natural law sources to come up with this notion of we have a common law right to privacy. So, with this background, I'm going to basically argue that the evolution that I will talk about in a little bit of this tort, which was recognized later on by Dean Prosser, who in the parentheses, after this decision was made, basically did a study, a survey, you might say, in the U.S. and figured out what are some of the lawsuits that are brought under the umbrella of a common law privacy tort. So maybe I should say this first. So he wrote an article, again, very influential, called Privacy in California Law Review, and basically observed all the lawsuits that were brought under the umbrella of a common law right to privacy. And in that article, he says, I think I see four trends when we look at all these lawsuits. So I'm going to call them, so basically he names them: one, appropriation of likeness or right to publicity, public disclosure of private facts, false light, and intrusion upon seclusion. So as it happened, he was also the reporter of the restatement. So lucky for him, he had the opportunity to actually put these four categories into the tort restatement. And ever since, we're stuck with these four categories of torts. And we have had rarely any new updates in terms of what new tort have been recognized, especially in terms of privacy. So here now, I want to argue that when we look at the tort of misappropriation of likeness or the right of publicity, and we look at the evolution of where it was recognized and what categories are included in that name or image and likeness, we have the opportunity to expand that tort and recognize it to protect our data. So basically expanding the notion of likeness. So the title of our talk is Right of Publicity. Maybe I should also explain why I refer to it as appropriation. So they're basically both from the same tort. So it used to be first we had the appropriation of likeness. As we saw more famous people, celebrities bringing these lawsuits, the core of the interest that was in question was a little bit of different from what a private citizen would bring. So a private citizen is really complaining about their notion of privacy being violated, whereas when you have a celebrity bringing similar lawsuit, they're not necessarily upset about their privacy, rather that their right to publicity has been taken without giving a compensation or then earning money out of that image that they've created for so long. So there was, again, scholars that basically came up with the terminology of maybe it's better when we have those type of lawsuits to call them right of publicity. And throughout the U.S., as Jennifer Rothman and Robert Post have an article on right of publicity, they do a survey, and they also observe that you have some jurisdictions that continue to refer to this tort as appropriation. You have some that have completely distinguished the two. They call it appropriation or right of publicity, and some that, under the umbrella of right of publicity, they also mean the same thing for private individual and call it appropriation tort. So if I'm referring to it as misappropriation or appropriation tort, it's the same thing for me as right of publicity, because I think that was the first tort, you might say, that the right of publicity grew out of it. Okay, so going back to my main thesis, which, again, I'm arguing for expanding the notion of likeness, that both private individuals and celebrities are able to bring and claim that their privacy has been violated. So this is the current definition of the misappropriation tort that you find in the Restatement Second of Torts, which says one who appropriates to his own use or benefit the name or likeness of another is subject to liability to the other for invasion of his privacy. So why do we even need this tort when we're talking about data privacy? Why am I even making this argument? I think this background is helpful because at the time when I was working teaching privacy, I found a case where an attorney, New Mexico's attorney general, basically brought a lawsuit against Google for their edtech technology that was used in schools, and said that alleged that the privacy of children has been violated, there has been unauthorized data collection, and the tort that he relied on was intrusion upon seclusion. As you saw, that was one of the torts that, one of the four torts that we have. And to me, intrusion upon seclusion wasn't really a good fit for data privacy because it actually, we don't have time to go into details of all of these torts, but it actually goes into the notion of the intrusion being really, first of all, in a private space, and also being offensive. And courts have recognized and did so also in that case, dismissing that cause of action. Privacy on the internet so far has become so commonly different than what we used to have that you can't really allege data collection to be highly offensive or being a private space, if you may think of it as private. So that's why I think intrusion tort is not really fit for data privacy protection. And then I said, but we have a better tort, which is the misappropriation tort. Let's rely on that one. Okay, so going into, again, the notion of the evolution of this tort, which relies on the notion of likeness. So we said we had the Georgia court recognize that there is a common law right to privacy, and that case was really one of the first cases in terms of relying on the misappropriation. But later on, we have other lawsuits coming in and really trying to expand this notion of likeness, because it used to be just name and image. And you saw that the first two cases, both Robertson and also Publicity, were complaining about an image, their image, being published without their consent. So in 1988, we had Bette Midler sue Ford. And what was this lawsuit about? So Ford made an advertisement, and before making this advertisement, they actually reach out to Bette Midler and say, hey, would you be willing to be part of this ad and basically sing for us or like let us use your music for the ad? And she says no. So what Ford does is that they go and hire one of her backup singer whose voice was really similar to her voice, and they used the backup singer for their advertisement. So once this ad is running, she finds out and she's upset, and she sues and complains that her right of publicity or misappropriation tort has been violated. So the court in this case agrees, says, yes, we think that the common law notion of a likeness is really more than just image. And image is just one of the means that you can use someone's identity. There are other ways of using someone's identity, and one of them is their voice. So in this scenario, we're going to say that voice is also part of that notion of likeness and your identity. And as such, you are able to rely on it to sue for privacy violation if someone uses that voice. And if we want to think about some maybe modern examples, you might have heard the story of OpenAI using a voice that was similar to Scarlett Johansson's. And from what I remember, they also had reached out to Ms. Johansson asking for her voice, and she had said no, but then the voice they ended up using at the time, not anymore, resembled really, really similar to Ms. Johansson's voice. And there was a lot of discussion about, was this also right of publicity? Was this similar to likeness? So instead of a backup singer nowadays, we have these synthetic voices. And in my opinion, the answer is yes. So in the evolution, again, you see that we now have voices that include as likeness. But then there was this other funny and interesting lawsuit, which fans of Wheel of Fortune may recognize. Any fan, actually? I don't know if this is too old or not, if people do still watch it. Yes, it's one of the longest running TV shows, I think. And in the TV show, for those who have not watched it, Miss White actually has a role of flipping the letter to solve this puzzle. Of course, nowadays you can just touch it, it's electronic, and at the time she actually had to do it physically. Nowadays you don't really need that character, but still she's part of the game show. And she saw that Samsung had used an ad in which if you see a robot is doing something similar to what she does at that game show. And Ms. Van White sues that, oh, my right of publicity has been breached, and how dare you, basically, this is a privacy violation. So the court, again, in that case, which did also involve some disagreement and dissent opinion, agreed with Ms. White that this, in fact, is her identity being used without her consent. And just because we were able to be reminded of her by looking at this ad, that's enough to trigger the use of someone's identity, which, again, you might disagree and say, okay, are we controlling what people think about and what people are reminded? That's crazy, but here we are, and this has been recognized as invoking someone's identity without their permission, and in other words, using their likeness, right? So the notion of likeness, as you see, this is 1992, kept expanding from an image to voice to even a lookalike. So where are we now at the moment? What part of our identity is being used by third parties? A lot, if not the most part. That is I argue, personal data. So our personal data is now being collected and used in many cases without our consent for the benefit of the collecting party. So can we as private individuals and even not private sue based on this lawsuit and claim that this is a privacy violation? In my opinion, yes, and we should call our persona or this likeness nowadays a digital persona. So we have a digital persona that's beyond our image and voice and lookalikes, but also includes our data, because data is becoming more and more personal, and my data is different than Professor Reid's data or Professor Kaminski's data. So that's the reason why we want to expand this toward. And in light of how states or actually the federal government have been unable to really pass a comprehensive privacy law, maybe this gives us an avenue. It's not ideal. We're talking about common law privacy torts, which are different from one state to the other, which that makes it complicated, but it also has some benefits. What are some of those benefits? And I'm not sure if I'm running out of time or not. I don't. Okay, so to me, some of the benefits of this is that it gives private individuals a private cause of action. So as you might have heard both yesterday, or you might also know, a lot of privacy laws don't necessarily give a private right of action, and if you do want to enforce those laws, you need an attorney general to go after. But for privacy torts, that has always been related to private individuals, and it allows private individuals to bring these type of lawsuits. Another interesting aspect of this theory and expansion of it, of course I'm not talking about the difficulties, and I think we'll get to that in the Q&A discussion, is also a matter of standing. So historically, claiming that you have been harmed for privacy has been difficult. But we have these privacy torts that allows us to have a cause of action and standing to sue for the purposes of concrete injury. And this, again, relying on a common law tort, does allow you to be able to claim that you have been harmed without necessarily being required to show any, let's say, physical or emotional harm for that privacy violation. I think in that sense, this is also helpful. So we can go into more details during the panel, but maybe just one last thing that I would say is that whether we have had any use of this theory or not, so Clearview AI has been a company that you may know has collected a lot of our images and data, and there has been 2 lawsuits that tried to claim that this data collection was in fact a breach of right of publicity in California. And the court, not ruling on the merits, but allowed the lawsuit to move forward despite a motion to dismiss by saying that there is resemblance to the misappropriation tort, and we do think that a collection of face prints and biometric data can include a breach of the privacy tort of appropriation of likeness and right of publicity. So I think I'll end here, and then we'll have more talk during the Q&A. Thank you so much.
Excellent. Thank you, Professor Takhshid. So I know we're going to discuss the legal dimensions of this. What are the right remedies for the kinds of harms that we're talking about here? Is the venerable set of privacy torts the right way to go, or do we have other approaches? Before we do that, though, I would love to get quick reactions, and let's try and keep it to a minute or so tops down the line, for other sort of takes on the kinds of harms and maybe the benefits of digital personas, digital replicas. What sort of problems, what sort of benefits do folks see? I'll start with Professor Kaminski and then head down the line.
Sure. So I should start from the place of I love this paper. You all should read this paper. It's a very important move in that most of the state data privacy laws that have passed, in fact, all the state data privacy laws that have passed, have not created a private right of action for individuals around their personal data. So this represents an alternate approach to giving individuals an ability to sue for data privacy harms that's really underexplored and therefore fascinating to me. With some major caveats. So the first move I want to make is just to be a little bit clarifying. So Zahra's work is really talking about the use of personal likenesses in the form of data for training AI systems. You could also very easily imagine using the appropriation tort for the output of AI systems. So if an AI system creates a likeness of me and it's used for that company's own, or the user who creates it, another wrinkle, use or benefit, it's likely I have a state appropriation claim under a lot of these state right of publicity laws. So just conceptually mapping out that here we're talking about training data, and later in the panel we're almost certainly going to be talking about output from these systems as well. So staying squarely in the training data space for a second, the benefit of using the appropriation tort to go after the use of my data as an appropriation of me is that it brings in dignitary claims into the American system. It gives a private right of action that didn't exist before, and that state legislators are reluctant, for some good reasons, to afford to people. The real downside, and this is me somewhat playing devil's advocate to myself, is that there's a difference between going through courts to create a right and going through state lawmakers. State lawmakers have chosen not to do this because of a lot of fear from the business community that it's going to shut down a lot of these systems. There are also a bunch of alternative models for governing personal data as training data. I'm just going to name a few and then pass it off to my co-panelists, but there's the biometric-specific law in Illinois, BIPA, which gives a prior consent model kind of similar to right of appropriation, but is more granular than using a state tort. There's law about scraping, which is federal law. Paul Ohm is an expert in that. And then even within these state data privacy laws that don't afford a private right of action, they still do impose things that implicate my personal data as likeness, including data minimization rules enforced by state attorneys general. And then I'm sure Anne-Marie will probably talk about some of the federalism implications here when these claims potentially overlap with copyright claims, with the idea that if, say, a court finds, and this is an if in my books, that these companies that have created AI systems have a fair use exception to copyright violation or fair use defense, and then they still face, and that's federal law, they still would face all these individual state claims for appropriating my personal data. So what do you do with that? I'm going to pass it off to Anne-Marie.
Great, thanks so much. I really appreciate the opportunity to engage with Zahra's article and want to preface my comments with the caveat that I'm not a privacy lawyer, and the right of publicity has only recently swerved into my lane as a copyright lawyer, and we can talk more about that in a little bit. So the question at the heart of Zahra's article is whether the concept The question at the heart of Zahra's article is whether the concept of likeness as it has evolved in the case law over time is spacious enough to hold and shield every form of personal data that might be collected. I like the idea of adapting old legal forms to new purposes, right? The impulse to find doctrinally plausible ways to patch holes that need patching in the fabric of the law. And I think Zahra is strategic to turn to the common law as a fertile field for this project. With that said, I don't think likeness in the context of the appropriation tort is elastic enough to reach all of the aspects of personhood and all of the data collection that Zahra would like it to reach. In particular, I see a dispositive difference in this context between biometric data and behavioral data. Likeness fundamentally is what someone looks like or sounds like. I don't think it's what someone acts like. Biometric data enables a person to be identified through their unique physical attributes, their facial, bodily, even vocal characteristics. It's data that tells you how a person is embodied in the world. Behavioral data, by contrast, tells you about how that person acts in the world, the traces they leave behind as they go about their daily lives, location data, click streams, purchase history, social graph. The data as likeness model wants to bring all of this information under the umbrella of the appropriation tort, but I don't think it all can fit. Both types of data reveal aspects of selfhood that the law can protect and that we might think the law should protect. But I think only biometric data, information about the embodied self rather than the behavioral self, fits within the conceptions of likeness and persona that can reasonably be covered by the appropriation tort. Thanks.
Thanks for that tee up, Anne-Marie. Mike, I want to come down for your reaction to what you've heard so far.
So I'm not a lawyer, and so my opinion and a buck will get you a cup of coffee. But I guess I have some questions about, because I've been on the other side of this. I've built a lot of systems using individuals' data. I think your point about your point about the sort of like behavioral versus biometric data is interesting. I also have some questions about, like, what is the set of definitions for what constitutes data? Like, if you have anonymized clickstream data, like, and it's like a unique ID that tracks this individual, but it's not tied to the underlying person. You know, that I have not read the article. I apologize. I didn't know that was part of the pre-work, and I want to recognize that as probably addressed. But that seems like one of the first questions for me is like, what is the set of digital exhaust that would fit the definition of like personal data? I think the economic costs are really non-trivial. I've worked at a lot of businesses that have GDPR compliance overhead, and it is a real drag on productivity. And I think that, regulation is about making compromises and like living in the real world and sort of dealing with harms. But I would welcome the panel to consider sort of the economic costs of complying with such a broad definition of likeness. And then I'm also curious about the scope of public data. So if I produce something, that's just, I know that you can take photos of people in public, for example, and that you have a right to, you don't have an expectation of privacy in public. And so I would say sort of intersects with what is the definition of data here? Is it clickstream data? Is it, my written content? Is it, a sociographic profile that Facebook imputes about me in terms of big five personality traits? If it's purely reconstructed from things that I have done in public, would that still be covered under this sort of definition? Those are questions that I had.
So I actually want to pick up with this question and with the way that Anne-Marie framed it in terms of differentiating between embodied data and behavioral data. And Zahra, I want to come to you for a reaction. When we're talking about the sort of likeness and appropriation, how do you think about this conception of data?
Did you want to help me out before?
I wanted to throw something in there in response to the privacy in public point. So one of the reasons that I, as a privacy scholar, or policy wonk, whatever you want to call it, get excited about this piece is that it bypasses that. So in other privacy torts, like intrusion upon seclusion, the question of what's private is very grounded in physical spaces often, and it's very binary. It's like, this is clearly private or it's clearly not. The thing that's amazing about the appropriation tort and about the move that Zahra makes in this piece is to say, we have a long-standing, everybody's described this binary issue of it's private or it's not, as a uniquely American problem that's basically eroded all the privacy torts and made them toothless. But we have this counterexample, which is appropriation, which is actually like, my face is public. I'm here in public. It's on the internet, right? And yet we've been recognizing that there's some sort of, whether it's dignitary-based, autonomy-based, whatever it is, there's some sort of intrinsic connection between me and my face that gives me a right at common law, which goes way back.
Mm-hmm. Thank you so much. So going back to Blake and my co-panelist comments, I have to preface this by saying that this is not ideal. Obviously, I think the ideal regime would be having laws that do clearly set out how to basically have a right of action for your data and for you to be able to sue based on a clear path that the legislative branch takes on. But because we don't have that, I think in the meantime, this would be a great option for you to be able to sue and maybe move some needles. And in fact, I think what has happened historically with common law cases is that they do create a narrative, and in response you might have the legislative branch coming in and passing laws that are basically reacting to that type of lawsuit that was brought about. So I think that's one of the benefits and one of the really powers of having a common law system where you can bring these type of lawsuits, and then if they're bad, then you might have a reaction. Bad in terms of not efficient, so going back to the economic loss that was mentioned. So yes, it might not be efficient, but we don't have a better option, at least now. And if we do want a better option, we should ask our legislative branch to actually pass something that can help us out or combat the floodgate of maybe lawsuits that you might have as a result of relying on the misappropriation. But I think common law privacy tort has its life, and that's what tort is all about. Torts grow. They grow in response to injuries that are created during different times. So the same goes with liability in negligence torts or battery and assault, and how it was it kept getting broader and broader in terms of even coming up with new forms of liability, such as products liability. So I think that's the beauty of common law torts, and that's why this tort, whether we like it or not, I think should be expanded in terms of recognizing our digital persona and our private data and our personal data to be included in it. But what kind of data and what about behavioral data versus our, as you put it, like embodied data? I think there's room for argument. I agree that it's, again, not easy to conceptualize that, but I would again rely on the Vanna White case and just how broad the court was able to say your likeness is. And if my likeness is even to the point where a robot that doesn't even look like me, in terms of like really like me, can trigger that notion of likeness and use of identity, I would argue that even behavioral data can be included in our persona and digital persona. And in fact, those behavioral data are things that are really distinguishing me from Professor Reid or from Professor Kaminski. So going back to what is personal and what is our identity, I think there is room for that argument. I'm not saying it would be an easy argument, but I could imagine that behavioral data could also be included. And I think the public versus private, Professor Kaminski answered that question, yes. So again, going back to the beginning of my presentation where I said that I saw courts relying on, or attorney generals relying on the intrusion tort, and one of the reasons that I think that was not the best fit is also the fact that intrusion is really about physical spaces, whereas when we're talking about misappropriation tort, we're talking about the person and the personhood of someone. So you can really rely on this right of publicity and misappropriation tort to expand that notion of person and extend privacy protection to the person.
I had one more follow-up question, which is really geeky, which is, as I had understood the right of publicity cases, there are a couple of them that are more recent that dismiss the idea that, so the gatekeeping part of the law is not the likeness part. I agree with you. Like, likeness is defined incredibly broadly, possibly with some significant free speech problems attached to it. But the gatekeeping aspect of the law is actually a use or benefit. So I wondered if you could talk about that. There are several cases that dismiss right of appropriation claims for, say, a credit card company gathering credit card consumers' purchasing habits. And they say there's no intrinsic commercial value in that in each individual piece of data. The value comes out of the list, and the list in a lock-in conception of property belongs to the credit card company that decided to put all that work into mining the list, right? Mm-hmm. So what do you do creatively around that argument that there's no commercial value?
Yes, that's also a very valid question. And I would respond by saying that in the camp of privacy tort scholars, there are two camps. So one camp is insisting that, in fact, you do need to use that identity, I'm going to say data, or that persona or that likeness for commercial use to be able to invoke this appropriation tort. And there's the other camp that actually says, no, there's nothing in the tort itself, in the common law cases, in the history of the tort that really says it has to be for commercial use. And I think courts, you might see them differ on this, but I personally don't think that it needs to be for commercial use. And I rely on also relatively recent case where you might have heard this in the news. It's not so recent anymore. I guess it was recent when I was searching this paper. But Shaq O'Neal, if I say his name right, right? Is this? Yeah. So him, that you know. He posted a picture on his Instagram account of someone who had in the image, the person looks disfigured, his face is disfigured, and he posted in a jokingly way trying to mimic that person saying like good morning or hello or something along those lines. And the person is a private person and their identity really doesn't really have any type of commercial value for Shaq O'Neal to really argue that, oh, I'm using this for commercial purposes. But he was able to bring a lawsuit relying on misappropriation, which was not dismissed, arguing that my identity was used, even though I'm a private person and my identity doesn't really have any commercial value for the purposes of this tort. And as it happened, actually that person had a kind of disability that had made his face look the way that it did, and really argued that you've violated my misappropriation by using my picture without my consent. The case was later settled, but for the purposes of our argument, the court said that despite him not having a commercial value in himself and the difficulty to argue that that post was really for commercial benefit of Shaq O'Neal, the case was allowed to move forward. So again, I think there's disagreement on this issue, but we can point to cases where despite not there being any commercial value to that misappropriation, which is different in most of the right of publicity cases where we're dealing with famous people, courts have been willing to allow the lawsuit to move forward.
So I want to shift us over to synthetic content, but Anne-Marie, since you got us down this road about the nature of data that's being protected and the question we just grappled with about the nature of harms that might accrue, any quick rejoinders on either of those points?
Well, I mean, I do think that there's something to the fact that we shouldn't have a right of action that can only protect the rich and famous. And so when we talk later on about the proposals that are alive now for protection of digital replicas that are the outputs of AI systems, you know, I think what the better proposals are ones that say, look, we all have a kind of dignitary or autonomy right in the way we look and in our embodied selves, you know, and that right of publicity, you know, as it's currently configured as sort of a primarily economic protection of an economic right, and those economic rights often are only possessed by people who are rich and famous and who the exploitation of whose identity is worth money. And I think that that is a real problem with the current, you know, formulation of the tort.
So let's shift over to, yeah, please, Mike.
Clarifying question. So, sure. On the topic of data, just as a thought exercise, like the perfect LLM replica of my taste and opinions, right? It's like Mike as a service. I'd be pretty pissed if that was online. If it was like, hey, we've taken everything that is knowable about you from the internet and created you, and now people don't have to talk to you or pay you anymore for your work. You can just be like, great, opinions on tap. I have a problem with that, for sure. Yeah, reasonably so. I think most of us would. At the other end of the spectrum is I am asked to generate random numbers between 0 and 100 and generate 1,000 of them. And that is my, like that data is used to train a Mike random number generator. Would both of those fall under your definition of likeness?
So how would in the second example your identity have been used?
Well, so I'm trying to like get at the question of like what is data? Like what is personal data? If data is likeness,
okay.
Like I think the first is much more similar to a likeness than my sense of like pseudo-random number generation.
Yeah.
PII scale.
Yeah. So in terms of what type of data we're talking about, in the paper, I argue that the best way, at least for now, would be to rely on personally identifiable data. So if it is a type of data that allows you to be identified, then you can rely on the notion of like your digital likeness to have been used. Of course, I think there are challenges to this because then we're talking about some of like public information that might have been used. But again, I think I want to argue that what this tort really is and how we should understand it rather than whether it's a good answer or a bad answer. To me, this tort would include those type of data, even though it might create difficulty and it might not be ideal. But it would include personally identifiable data. And one of the cases that I cite is Cohen, which is the case where a mother and daughter whose face were not even showing in an image, their image was used by someone who had taken it without their consent and published it in a magazine, I believe. And the father of the daughter and the husband basically sees that image and is able to recognize that, oh, this is my family, and sues based on the misappropriation tort. And the court says just because we're able to refer by the circumstances that this image is in fact that person, we're allowed to use the misappropriation tort and say that their identity was used without their consent. So I think if it is personally identifiable data that you're able to recognize someone, even some of it being anonymized, but you're able to de-anonymize it, it would include, in theory, in the scope of this notion of likeness for the purposes of this tort. But whether that's ideal or not, it's a different question.
All right, so we've been talking about the sort of collection and the input side of data. Let's shift to the output side, the synthesis, generation of content. We've got another set of laws to deal with that. Professor Kaminski, over to you.
Okay, I'm going to try to cover a lot of ground relatively quickly. I also want to just flag this was probably the most fun set of classes for me to teach in the AI law class I was teaching this fall. So the reason this stuff is so fascinating to me is that we always talk in law and tech about how technology potentially moves faster than the law. We also talk about how existing law can be updated to get at the underlying harms of technology. This area right now is, to me, just this grab bag of different possible legal approaches that haven't yet really stabilized. And across different states, you see a lot of different approaches to synthetic content in a lot of different realms. So the first thing I'm going to just do to, again, reorient us to say these laws I'm about to discuss are really concerned not with the input into AI systems, like the training data. They're concerned with the output of AI systems, whether that be voice generation, synthetic imagery, video, et cetera. And they really coalesce around different pockets of characterizations of different kinds of harms. So you can think about some of these laws are really deeply concerned with economic harms. For example, laws that are coming largely out of the music industry that are concerned with the use of Drake's voice to sing a song Drake didn't write without Drake's consent, right? Then there's the more autonomy harms, which are really about control. And if you sort of have this gut reaction of, I really don't want to have an advertiser use my face to advertise something that I have no interest in. Classic example from these appropriation cases, by the way, is the athlete who doesn't drink, whose image is used for a beer advertisement. So if it's really for you about control, that's a different kind of legal mechanism. And then there are examples in a lot of cases that are around like quintessentially dignitary harms. So if we think about what's now referred to as non-consensual intimate imagery, in the recent past referred to as revenge pornography, these are in the synthetic version images of people, in the nude or in sexual context that they did not consent to, nor did they actually perform. And then finally, the last category of harms are harms to democracy or society. And those, if I just give a brief example, are these laws about the election and synthetic content. And those are interesting because, we have this shift in privacy scholarship from thinking about whether privacy harms are truly atomistic, they're truly about individuals, or if they're harms that are about society and changing the nature of the functioning of our democracy. And those laws, again, their mechanisms look different. So I'm going to talk about a couple of state versions, and then I'm going to talk about two federal approaches, and hopefully we can have some conversation about the pros and cons and limitations of each. The other backdrop for this is that on my final exam in my AI class, apologies to my students, I asked them to consider whether it's better to have an omnibus approach, meaning a one-size-fits-all approach to synthetic content or deepfakes, or to have sector-by-sector approaches, meaning that you truly think that the replication of a celebrity's voice is different in kind from electoral synthetic content is different in kind from non-consensual intimate imagery. So which route do you go? So first we have a number of states, Ellen Goodman mentioned this yesterday, that are basically taking the right of appropriation and making it or right of publicity and making it the right of publicity on steroids. The most famous and funniest of these, funniest title of these, is the Elvis Act from Tennessee, which you referenced yesterday, which in addition to requiring consent before you use a person's voice or image, also goes after, flagging this for discussion, both the distribution of that and the provision of technology to make that replica possible. So it targets, backed by civil action, the provision of technology that allows you to make a synthetic voice as long as the primary purpose of that technology, it's debatable what that is, primary purpose of that technology is basically voice fraud. Then we have other examples from other states around both electoral content and NCII. The electoral laws, interestingly, often hinge on disclosure. So California's no deepfakes in the election law puts in place a whole bunch of obligations backed by, including one backed by an injunction. So you can go and say, stop using this image, which is extraordinarily powerful relief. But it says none of this stuff is going to count if you, or kick into gear, if you disclose prominently this image has been manipulated or this video has been manipulated. So that kicked off a class discussion in my class of like how important are these disclosures or how convincing are these disclosures if you see a video of a politician 25 days before the election doing something they didn't do and it influences your vote. Are you really going to, and given lack of trust in media, are you really going to look at that disclosure scrolling across the bottom saying this image is manipulated and take that to heart? Then in the NCII context, the non-consensual intimate imagery context, we have laws that either amend existing laws about non-consensual intimate imagery and just throw in the or if it's synthetic, that counts too. But we also have laws, again, in California that go from whole cloth and basically, again, are really consent hinged. So it's about, did you obtain the consent of the person before you distributed this imagery? And then I'm trying to do this as quickly but efficiently as possible. Two examples from the federal context that are really different and interestingly different. So one is the FCC's Telephone Consumer Protection Act. Who here hates robocalls? Who here loves robocalls? Those of you who didn't raise your hand. Okay, there is bipartisan consensus that telephone spam is terrible, to the point where it's one of the few places that this Supreme Court, the Roberts Supreme Court, has said, wait a second, we're not going to use the First Amendment to say that spam callers have a right of free speech, right? And that's bipartisan. So what the TCPA does is it doesn't go after, ostensibly, the content of the robocall. It goes after the robo nature of it. And this is an old law, so it's also interesting that we're now kicking into gear using it for AI-generated content. But it very clearly says in that law that if you are going to place a call that has an artificial voice, that's the language from the statute, an artificial voice in it, you have to get prior express consent from the individuals you're calling. All right, so what does this mean? This means that the FCC and litigators can go after anybody who places AI-generated calls without prior consent. It goes after the mode of communication, not the content of communication. However, and it's really interesting to think about how this intersects with free speech, because the FCC 2023 issued a forfeiture notice or order that went after two gentlemen who were placing not artificial voice calls, but auto calling calls, around 1,000 of them, that the content of which said, don't register to vote in the 2020 election, because if you register, that creates a database and the cops will come after you for outstanding warrants. And these guys argued, well, that's political speech. And the FCC said, oh, no, this wasn't about the speech, right? This was about the robocalling, and got a pretty significant amount of money from these gentlemen. All right. So then the last one I'm going to talk about is the Federal Trade Commission, which, as most of you might know, is our federal consumer protection agency, traditionally goes after things like false advertising, also has been in the data privacy space. What the FTC has been doing here specifically is rulemaking, which is really unusual. They have a rule about impersonation of a business or government official, and they started rulemaking on impersonation of an individual. So their paradigmatic case for AI-generated content is grandma or grandpa picks up the phone, their grandchild is saying, that's the voice they hear, their grandchild saying, I lost my credit card, I'm stuck in this train station, I need you to wire me money, otherwise I won't be able to get home to mom and dad, or mom and mom, or dad and dad. And the FTC says, well, that's a significant harm. We have evidence that this is extracting a ton of money in the form of fraud from elders. And so we should have a rule that says you cannot impersonate an individual. Now, what's really interesting about that, again, if you think back to the Tennessee law that went after the technology, the FTC also proposed going after the means and instrumentalities of creating that voice fraud. So going after the algorithm that creates the voice fraud. And initially, there wasn't a knowledge requirement. It was just go after it, basically strict liability, if it's used to create this voice. So there's your menu of different possible regulatory options, ranging from prior consent to enforcement by an agency to let's go after the fact that it is AI generated. And I hope it'll give rise to some fruitful discussion.
All right, so we are getting close to needing to turn to the audience, and we've got some big issues that I want to get on the table before we do that. I have cataloged them as follows. I think, one, we have federalism, so we've got this ongoing discussion from yesterday about are the right approaches here state laws, federal laws? What about issues of preemption? Anne Marie, I know you want to say a word about that. We've teed up the First Amendment as a potential problem here, and I think earlier on the panel, Mike raised the question of economic and compliance harm. So federalism, First Amendment, economic compliance concerns. I'd like to go down the panel, start with Anne Marie, then go to Mike, then Zahra and Margot, I'll give you the last word with your thoughts on this, the sort of menu of potential problems here and how you might approach them, and then we'll go to the audience for Q&A.
Yeah, so I'll talk a little bit about the federalism issue from my point of view as a copyright lawyer. And this comes because I don't know if you all remember the Kool-Aid commercials from the 80s. I will show my age, where the Kool-Aid man comes crashing through the brick wall. Here comes Kool-Aid. This is what happened to me as a copyright lawyer when the U.S. Copyright Office, when it issued its notice of inquiry in 2023 on copyright and AI, decided that it would raise some questions for the public to opine on about the right of publicity. And I think it bears mentioning that the right of publicity is outside the scope of the copyright law. It's outside the scope of the Copyright Office's jurisdiction, therefore. But it is of acute interest to the music and film industries, which are major copyright stakeholders. And so Margot has already mentioned the role of the music industry in pushing the Elvis Act. And I can talk really briefly about some federal legislation that they have also brought forward. But interestingly, the Copyright Office, the first of the 3 reports that they published, it's going to be a tripartite effort because there's so much to talk about in the world of copyright and AI, was actually on this non-copyright topic, which they call digital replicas, right? So synthetic imitations of people. And the office made some pretty specific recommendations for federal action in this area, including some but not full preemption of existing state right of publicity laws. And so a couple of points that I'll talk about from their recommendations that dovetail with what we've already talked about. One thing that they said for subject matter was it should be digital replicas so realistic that they're difficult to distinguish from authentic depictions. So it really is this case where you could just pick up the phone and hear your grandchild and think it's your grandchild. Persons protected all individuals, not just celebrities, public figures, or those whose identities have commercial value. And I think that is definitely the right approach here. Infringing acts, distributing or making available, but not creation, right? And so this is a way in which the music industry bills actually diverge from the recommendations that the Copyright Office has made. Should require actual knowledge in terms of scienter of both the covered subject matter and the lack of authorization for the replication. Let's see what else. Licensing, okay, but not assignment, right? So this is so intrinsic to yourself that you should not be able to alienate it by assigning it. But of course, you know, one of the bills that's pending federally, or not pending anymore, but was pending in the last Congress, the No Fakes Act, creates this elaborate sort of licensing regime, right, where you can exclusively license your rights and your digital identity to someone else, which is interesting because exclusive licenses in copyright law are actually treated as assignments, but this is not really copyright law, so I guess. So that's an interesting part of it. Like, you know, are we wanting to? It's the bill is called the No Fakes Act, but really it's geared toward creating a market in digital replicas. So it really is the Let's Create a Market for Fakes Act. So anyway, one more bill that I want to talk about in the federal mix is a bill called PADRA, which Representative Issa had circulated in the last Congress, first as a discussion draft, and then I think it did get introduced. And that's a different approach. That's a bill to amend the Lanham Act, which is the Trademark Act. And it sort of piggybacks on issues related to false advertising, like Margot discussed with the FTC, and sort of false designation of origin. And one of the problematic aspects of that act is it creates a presumption in favor of the plaintiff of the likelihood of confusion, which, if you know anything about trademark law, is sort of giving away the whole thing, right? Because likelihood of confusion is what you have to prove, and basically PADRA says you get the presumption that that's already proven right out of the gate. And so one other thing, I think it's really important for regulating in this space that we not go after general purpose AI tools. I think that is kind of innovation crushing without actually addressing where the harms come from here. I think we have to focus on the fact that the harms do not come from the creation of these replicas. They come from the public circulation and publication of them. And so we should be focused on that. And if we want to create some form of secondary liability for UGC platforms, for example, you know, I think we can do that in a kind of tort law context, but importantly with some strong safe harbors like the ones we see in the DMCA. So with that, I'll stop.
All right, slight audible. Mike, I'm going to come to you last because I think we're going to drill in these legal questions for one more second and we'll get your technologist reaction as the closing word. Zahra, your thoughts?
So I would just, I don't have much to add again in this part, but maybe the only thing that I would say is looking at the trend in terms of passing postmortem privacy rights and the digital replicas. I think there's a lot to say there as a trend where we're now seeing that states are coming in, and New York being one, and yesterday, again, as Margot also mentioned, Professor Goodman talked about California having now a postmortem right of publicity in addition to Tennessee and other states. And I would just add that I think there's a trend in terms of recognizing that the synthetic media needs us to react to it, and we need to have a clear path in terms of what to do and how to respond to this new wave of harm that are being created. And I'm happy to see that states are actually taking action. I think that's it.
Yeah, so I want to just re-emphasize the different harms get different legal mechanisms point. So if we think about this really as being about protecting celebrities who have earned economic value in their images or their voices from having that exploited, right of publicity or similar laws look like a good-ish fit, right? If what we're concerned about instead is harms to individuals who are finding themselves in non-consensual intimate imagery, it's a very different type of law. You don't try to create, instead of the No Fakes Act, the Fakes Market Act, right? You try to empower those individuals, sometimes with injunctions, to get those images taken down, which might, apologies to Anne-Marie, might involve thinking about takedown regimes and online intermediaries. The additional point on this, and I wouldn't be a comparative scholar if I didn't bring it up, is that then one we haven't talked about yet is the Europe's Digital Services Act approach, which is to actually say for very large online intermediaries, you task them with managing this problem. How that plays out in actuality and how that plays out vis-a-vis the First Amendment leads us into a whole complicated mess of questions. But it's to say the consent model is not the only viable model. The risk management at scale model is something that might be appropriate to, for example, harms to democracy in the electoral context.
Mike, final word before we go to the audience.
Yeah, and I'll just say that I need to leave before the audience Q&A. But I think on the topic of should this be sort of legislated at the state level or the federal level, it seems to me I hadn't really considered that it might be a state-by-state regulatory regime, and that just sounds like a waking nightmare from a compliance standpoint for two reasons. One of which is that, is it like where the IP is? Is it where the servers are? Is it where, is it where the robocall is being placed to? It just, from a data management and sort of like compliance standpoint, it would be very difficult to ensure compliance with 50 different regulatory regimes. I don't know that that's a reason not to do it, but it just would be a real tax. But then also I just think the issues are complicated enough. Candidly, I don't know that every state legislature is equipped to come to good policy on this stuff. It's like super complicated. And it seems like a consistent, very deeply thought out regulatory regime at the federal level as a citizen seems preferable to me.
All right. With that, we go to the audience. As always, the wiser rule demands calling on a student first. It's Monday morning, which means a lot of our students in class. We may extend this rule to former students, of whom I see a couple, and I see a volunteer right here. If you could please say your name for folks online.
Hi, Taylor Hartley, cybersecurity expert. So I am a technologist, so I kind of feel like policy isn't really going to fix this. The data's already out there. It already exists. I mean, the max you could do is honestly probably not much, right, regulatory-wise, especially under this admin. And even then, what we prevent these OpenAI models from generating this content just so people can go on the dark web and use dark versions of them to still generate it and still put it out everywhere. So instead, as a technologist, I think that we probably need to focus on the other side and how can we leverage tech to maybe verify real people, right? And kind of doing the opposite way. Like, okay, these are photos of me from my verified accounts, right? And everything else is just kind of nonsense. And I think we're getting to a place where, I don't know, we question every photo online. Is this real? Does the Pope wear a puffer coat, I think we've already made that switch in our minds. I don't know, from my side, and maybe even to like Mike's point, if it gets to federalism, I mean, as a vendor, I probably just won't sell to your state if the ROI is not going to be worth it.
So I think shots fired at the legal experts on the panel. What do you all think of this notion of, are any of these regimes likely to be effective against the sort of river of AI generated content?
Can I say? So I think this is a little bit of a orthogonal question or something, but there are also bills relating to data provenance that have to do with, finding standards or ways to cryptographically and permanently mark synthetic data as synthetic data. So for example, for Google's image models, we have something called SynthID, which is a system for doing this, and many of the other AI developers have similar things. I think Adobe has its own way of doing this kind of provenance marking. I do think it's important, when we talk about the kind of information ecosystem harms that come from synthetic content, the provenance piece, I think, is an important one.
I was going to say exactly that. So the proposed 2023 Deepfakes Accountability Act at a federal level had a content provenance provision that said, what we really need is to have the disclosure of whether or not this comes from an authoritative source. And the DSA has similar mechanisms sort of in its scope. The concerns about doing that are twofold. One is that trying to trace content provenance is really hard, and it's very easy to get around. And so the tech solution is not a perfect tech solution. And if you go down, as I have, down the rabbit hole of looking at like what tech is actually available, not a technologist, but understand the policy summaries of it, this is a problem we've been trying to solve, including in the copyright realm, for a very long time and haven't been able to solve. The second concern, I keep coming back to non-consensual intimate imagery, which is that if there's no liability for distribution of non-consensual intimate imagery, and that is a policy solution, not a technology solution, then it will be distributed. And to Anne Marie's point about the harm coming from the distribution, the social harms, the autonomy harms, the individual harms, that's a place where law can target it, and it will affect behavior.
I would just pick on what you said in terms of our mind has shifted and us now questioning everything, and just say that I think to me that's a very important aspect of our understanding of privacy and data protection, because in torts we also talk a lot about reasonable person. Of course, there's the question of who is this reasonable person, but I think that notion of maybe a reasonable person's understanding of privacy really comes into play when we're thinking about all of these questions in general, and I think that's important.
All right, I have spied with my eagle eye a couple of actual students down in this vector of the courtroom. Let's go to David down front, and then we'll do the wiser corollary and keep going with students with Nicole in the back.
Thanks for the panel. It was really, really interesting. I'm a third-year law student here. I'm going to pick up where Blake teed y'all up for, and you addressed other things, but I want to talk about the First Amendment, not to pander a little bit to Blake Reid, but I think there's a really interesting tension between the First Amendment and the right to publicity type issues. And I particularly, I'm thinking even of the child pornography cases where some digital types of cases and digital harms that are made of synthetic data aren't recognized by the Supreme Court as First Amendment violations that way. And so I guess, what are your thoughts on that tension between the First Amendment and these issues?
I get to take this because I taught it. So morphed CSAM, thanks for introducing this topic because it's gross. The federal framework or the Supreme Court framework for child pornography is that child pornography is an exception to First Amendment protection, full stop, but completely made up images of children are protected by the First Amendment. So what do you do with what's called morphed child pornography? And yes, this happens enough that it comes up in multiple federal courts of appeals under multiple different states. What do you do when somebody takes an image, either takes an image that is of a photo of a child's face and puts it onto graphic imagery, or just generates it in a way that it's identifiable as the child, not using their face? And initially, courts of appeals were inclined to say this is more like, and there's still a split, this is more like entirely generated child sexual imagery, because there's one of the things in the Ferber case, the Supreme Court case finding it to be an exception, is that there are two prongs of reasoning for why it's an exception to the First Amendment. One is this, you are actually committing, it's speech incidental to criminal conduct, so you're actually committing an underlying crime by having the child sexually abused. And so we can go after it because it's incidental to criminal conduct. The other one is the dry up the marketplace rationale, which occurs almost nowhere else in First Amendment doctrine, that says it's permissible for legislators, given the harm to the child of just the autonomy harm of and dignitary harm of having that image out there, to go after drying up the market. And multiple courts of appeals, in short, have taken that and said, even without the actual underlying act having happened, this is a First Amendment exception.
All right, let's head to the back.
I'd like to expand the First Amendment question specifically to deepfakes. Of the regulations that you've discussed or regulations you see being proposed, what do you think is most likely to survive a First Amendment challenge, given the court's indication in Alvarez's case in 2012 that the lies need to be, there needs to be a long history of regulating lies in order for the regulation to survive a First Amendment challenge.
And maybe in just thinking about the menu of laws that we have teed up today, we've got a lot of options. Do you have, what are our odds looking like?
Sorry to dominate this part of the Q&A. So you're correct. Alvarez basically, along with a number of other cases right around that same time period, ossifies the existing exceptions to the First Amendment. So it says things like, we're not going to do a balancing test to ad hoc create a new exception to First Amendment protection. So unless this exception was around for a long time, like defamation, fighting words, et cetera, obscenity, we're not going to create a new one. And a lot of these laws govern content that would technically be a new creation. What I would point you to is the lower court decisions on the non-consensual intimate imagery question pre-synthetic content, where we found, I think, at least 3 different state Supreme Courts either doing one of 2 things. They either say, sure, but we think that this is a new exception, right? Or they apply strict scrutiny, which laws rarely pass, but they say the interest here, the affected person's interest, is so great that this narrowly tailored law, which just requires consent before distribution, that passes strict scrutiny. Or option 3, and this is kind of connects with the FCC's TCPA approach, this is about mode of distribution, not about content. So what we're really talking about here is not you can't say this thing, but you can't say this thing without consent. And those are the ones I find to be most interesting. Whether I think they're good law or not is another question.
Add just something to the previous question in a general response to right of publicity and its clash with First Amendment. I would just note that despite the apparent clash, the right of publicity has lived on and has survived Supreme Court challenges. And one of the famous cases that typically tort scholars cite to is Zucchini versus Howard Broadcasting, in which there was a human cannonball show that was videotaped and completely broadcasted on TV. And the Supreme Court said that there's no way that you can use your First Amendment by violating this type of misappropriation and right of publicity claim. So I would just cite to that case.
All right, with that, I will have to apologize for the remaining questions in the queue. We'll keep it going during the reception. I'll turn it over to Brad in just a sec for our stage directions, but please join me in thanking our panel for that discussion.